So if you'll remember the intro I gave this morning for Mark Limley, it was, if you need an introduction to Mark Limley, you're at the wrong conference. The same introduction applies here. Andrei Iancu, I don't know how many titles we need here, but other than former managing partner of IRL, which I think is important to this discussion because he's been in this mix of both plaintiff side litigation and defendant side litigation for all of his career, from IRL and now at Sullivan. And then, of course, the former director of the USPTO. So, Andrei, thank you for joining us.
Great to be here. Thanks for the invitation.
So, Andrei, I want to start with you. You've seen the discussions today. Of course, most of this is a defense-oriented crowd, but we've had a fair amount of, let's say, counter discussion today. But a lot of it comes up on, what is the current state of the IP system in the United States? And so looking beyond kind of the nuances of injunctions or looking beyond the nuances of just what's going on at the PTAB, what do you see as the big picture IP issues facing us as a nation right now?
Yeah, well, just sitting in the audience and listening a little bit to the various panels, it was the best part of the day was hearing that, the FinTIF factors look pretty good right now. Who knew? But yeah, so look, IP is at a significant crossroads, I think, in the United States and globally. So just looking at it from 30,000 feet, there is a very significant tension on IP. It's being pulled from multiple sides. Now that tension has always existed from the very beginning of IP. Back, when Jefferson was reviewing patents. From the very beginning of IP, you have this tension between the need to protect the creator versus the access to that of the public to that creation. That's why IP needs to be balanced and have in mind both sides, because that's the whole point of IP. Protect and provide public disclosure and therefore access to the innovation or to the creation. Now, that tension is on steroids right now. So we can see it in the discussions that you all have had during the day today. I'll give you just the example from the current administration's perspective and what we see coming from this administration. On the one hand, you see a lot of what can be characterized as pro-patent owner actions, right? So, a couple of panels ago, we talked about events at the PTAB and all the actions the director is taking and the prior acting director took vis-a-vis IPRs, which seem to be very pro-patent owner. There is a new NPRM, the Notice of Proposed Rulemaking, that is floating out there that also can be characterized as very pro-patent owner, and we can talk about that. They have made statements, strong public statements, in favor of injunctions. The administration, not just the Patent Office, but the Patent Office together with the Department of Justice, put in a statement of interest, completely voluntary. They injected themselves in an actual patent case in Judge Gilstrap's court at the preliminary injunction phase, where the plaintiff was a non-practicing entity, and said preliminary injunctions and injunctions in general are really important for the patent system, even if the plaintiff is a non-practicing entity. That's in the Radian case. And again, you can characterize that as a very pro-IP, pro-patent owner action. You see comments from the Department of Justice with respect to standard essential patents and the like that seem to all go in that one direction. So that's on the one hand. On the other hand, you have many statements from the same administration that can be characterized as being very concerning to IP owners. For example, the Secretary of Commerce, Howard Lutnick, has said that, that the United States government needs to get a, quote, return on investment, as if the United States government is a hedge fund, to get a return on investment from various patents out there that are generated, at least in part, with government funds. So they're talking about potentially exercising margin rights with respect to university patents and other federal funded research, which would be a big concern to the startup economy and to the innovation economy in general. There are rumors about a broad-based patent tax on all patents, by and large, based on some assessed value of those patents, even if they're not actually monetized. So again, I emphasize that's just a rumor. There's nothing concrete on it. So you see, those are can be viewed on the other side of this. Then on the copyright side, you have the president has opinion on fair use now, and said publicly that that for AI companies to be able to compete, they need to have effectively free access to content, which would be a very significant concern to content owners and copyright owners. There is this huge tension going on. You can see this manifested on drug patents. And, you know, there's a very significant push to create more and more innovation in the United States, onshore innovation and development into the United States. Yet at the same time, there's all sorts of talk about limiting patents in various ways when it comes to drugs. Same thing in the standard essential patent area. So it's not a very concrete answer, Wayne, but only to say that we have, you know, if we're thinking at the high level, we have this constant tension, at least in the United States, and that gets magnified when you look internationally and see what the European Union is doing, the Chinese, and others as well.
You know, so it's easy, and today you saw lots of people take shots at the administration, and it's not just this administration. You know, 4 years ago when you were director, people were here taking shots at that administration. I love
unfairly.
Unfairly, of course.
But, you know.
But FinTIV was terrible. Those kinds of things happen. But I want to ask about something else, if there's something that we're not talking about enough, and we saw a little bit of it today, but any kind of IP system, a patent system, is two parts. It's like the old Seinfeld, you know, there's the two pieces. You've got to take the reservation and keep the reservation. At least people in here still remember Seinfeld. I can't use that with students anymore. But for a patent system, you need the procurement piece, which the USPTO does a good job, but you need the enforcement piece. And the administration has very little control over the enforcement piece, at least when it comes to district courts. And we heard today that the numbers of what people can expect to pay. And litigation funders aren't interested in any case that doesn't have a $100 million damages number. And I'm not talking about the low-end patent enforcement entities. I think Mark refers to them as smash and grab. We're talking about real innovators, but it's $100 million. You heard Boyce Schiller say that that's their entry-level number. And a lot of people I heard groan, some kind of in disbelief, but I think that number is pretty close to correct. So are we now looking at a system, I don't care how good your patents are in the US, that you're stuck with needing $100 million to actually do anything with them?
Yeah, look, I think that's approximately right, you know, at least on the order of magnitude. Look, litigation in the United States is extraordinarily complicated and expensive. You know, when I was at the PTO, I used to say that there is an unwritten statute on patents, Section 101.5 or something, that mandates patent law in the United States shall not be simple. And if you try to simplify it, you're violating that statute somehow. It only gets more and more complicated, and therefore more and more expensive. And frankly, it gets to the point where it is not where patents are not meaningfully enforceable. If it costs $10, $15, $20 million to enforce a patent, and it takes 5, 10 years to get to a final resolution, if you're going to go through the court system and not have a settlement, very few inventors, patent owners can actually afford to go through that exercise on their own, whether it's financial or whether it's the span of time. By the time you get to resolution, the competition will have killed you. For a patent to have any value, obviously, as you say, you have to procure it. That's the first step. Great. And the PTO, does a good job at that. And they're not as fast as they could be, but you still can get a patent in about 2 years plus, give or take. Okay, but then if you cannot meaningfully enforceable, it's as if you really don't have a patent. And the small, medium enterprises, I think, have a very difficult time in this environment. So what happens? So they have to resort, at least from a financial perspective, they have to resort to third-party funding, which has its own issues. A, that money is very expensive. And B, you see the public pressure that's now being put on that system, both publicly and in courts, like in Delaware and in Congress right now. But it's hard to understand what other options you might have if you don't have at ready disposal $10, $15, $20 million. And look, even if you get beyond the finances, who has the wherewithal to stay with it for 5 years plus in a fast-moving technological landscape? So now, that's why, and you've heard on prior panels, that's why patent owners look at other jurisdictions to try to enforce perhaps in a more reasonable way financially and also faster. The UPC is a good example. We'll see how that plays out. It's very young. But people think that, that could be or is already a much more reasonable jurisdiction. Germany is another one, has been for a long time. Brazil, of all places, Colombia. I heard Nigeria today. I haven't heard that before. So people are trying to see if there is, which is shocking, right? You have American industries or international companies that do big business in the United States, American innovators looking elsewhere to enforce their IP. I think it cannot lead to good things in the United States. By the way, shockingly, I don't know if folks have heard, maybe it came up on one of the panels, there's a case currently against BMW. Did people talk about this today?
Just for a minute.
There's a case against BMW in German court where they're enforcing United States patents. So the German lawyers need to explain to us how that is going to work. But that type of expansion. So just think about the options here. If you have a good U.S. patent and you want to enforce against a German company, why would you sue them in the United States? That has basically no injunction and or very difficult, takes a long time, it's very expensive. Might as well go to Germany and enforce your U.S. patent. It's wild times.
So a lot of the European attorneys that I've been talking with have been talking about not enforcing U.S. patents abroad, but what happens with the next generation of innovators. If patent systems matter, if they're really a boost to innovation, if you can't predict, or there's no predictability in enforcement in the U.S., are we at risk of falling behind Europe with their new system? The EPO does good work. If the UPC covers 340 million people in 12 months at 20% of the cost and has an injunction, does that new generation of innovators, small, medium enterprise type innovators, do they come out of Europe for the next 25, 30 years?
Look, I mean, the patent system is one component of the innovation economy, but it's a very important one, and I think it's very problematic. By the way, you say that the EPO does a good job, and they do, but really not as good as the USPTO. I'll just say that because the EPO guys, I don't know if anybody's here from the EPO, they just tout themselves that they're so fast and so good. They have good quality metrics, which they themselves generate. They're so fast, and they seem faster than the USPTO because they only count the number of days a patent is with them. When the application is with the applicant for the responses, they don't count that as pendency. So I'm just saying. Not because we're competitive or anything. But the bottom line is, if you don't have in the United States a good enforcement mechanism, and other jurisdictions, Europe, China, have good enforcement mechanisms, everything else equal, okay? Because again, there are multiple prongs here to innovation. But all else equal, you will have less innovation in the United States than in these other countries. There's no question about it. This is a free market economy. And people say, well, it doesn't really matter because these are international companies. Well, but no, the startups are not international companies. The disruptive innovation happens by and large on the edges, and by and large, disruptive innovation happens in the startup economy, in the garages, in the university laboratories, and the small startups. The real disruption, Apple was once a startup, and the first Macintosh and whatnot, that's disruptive innovation. Now, of course, Apple kept innovating, but the real disruption is at the beginning. Google, I mean, all of these companies began as startups. The same thing happens, in the pharma space. And, inventors, their first market is the domestic market. It's hard to say to an inventor that, might have a garage enterprise like the famous Hewlett-Packard garage here in Palo Alto back in the day. It's hard to tell them, okay, well, yeah, you can work here in Palo Alto, but you know what? As soon as you get successful, you're going to have to go fight your competitors, I don't know, in Nigeria. I mean, it makes no sense. You want to protect your own domestic market first. If you don't have that, on the edges, you're going to have less innovation in your domestic market. So it's critically important. It's especially important here as compared to China. In a free market economy where there is no centralized government that dictates where we shall invest our money, that investment needs to feel that it's protected and enforceable if successful by the rule of law. And if we don't have that, we're going to lose. And by the way, this is already happening. It's not a mystery. There are studies from various think tanks. One of the more recent one is from an Australian think tank that shows that China is leading in something like 48 out of 53 emerging technologies. Those numbers are approximate. I don't remember exactly, but it's of that magnitude. We've lost the edge already in the majority of new and emerging technologies, and if we're not careful, we're going to lose the edge in the rest of them.
Well, as we go back and talk about the AIA and IPRs, but there's a bigger picture to that. When you go back and look at the legislative history, one of the goals was to help reduce the cost of litigation. And there's not a whole lot of debate about that. It really hasn't helped on that front. What do you see the future on this needing to be if post-grant procedures are actually going to reduce costs for especially small, medium enterprise type inventors?
Yeah, so look, there's a lot of debate right now as to what's happening with IPRs. And IPRs have been at the forefront of conferences like this ever since they came to be about 15 years ago, 13 years ago. The whole point of IPRs was to create an alternative, less expensive way to challenge a patent than in district court litigation. So it had, the goal was to be an alternative to district courts and less expensive. It hasn't happened from at least that perspective. It is almost always in parallel with district court litigation. 85% or so of IPRs have co-pending district court litigation. And it hasn't, because of that, it hasn't become cheaper. The IPR itself is certainly cheaper than the district court, but it's additive. It's not the substitution most of the time. Now, there are many, so at least from that perspective, I don't think the goal has been achieved. There are definitely goals that have been achieved. I think that the PTO did a good job hiring very good judges over the last decade, and they're specialists. They never miss their deadlines. They issue their decisions, final written decisions, always under the statutory 12-month period. They're detailed and reasoned and thoughtful. And so if you want expert opinions on the validity of patents, they definitely achieved that goal. But there's so many, in my personal view, there are so many loopholes and flaws in the statute and the way it's been implemented that's caused this constant debate, and I don't think it's healthy. And with different PTO directors, it goes back and forth and back and forth, and it's just an unhealthy situation. The reality is that patents are a long-term investment, and you have to have some predictability. And just look at the panel you had here just 2 panels ago. Nobody really knows what's coming next. It's like, and we just had, you had the system we had when Michelle Lee was the director, then I came in and I made some changes, and then Director Vidal made changes, and then Acting Director Stewart made changes that are completely different than the prior director, and now you have Director Squires making even more changes. And they're proposing an NPRM that got, well over 10,000 comments yesterday. But it's unclear if that's going to be the end-all and be-all. For example, everybody on the panel talked about settled expectations. I don't know why anybody here thinks that that's still being used. Maybe it is. How do you know? How do you know? It's not in the decisions, obviously, since it's a one-word decision now, and it's not in the NPRM. So we just don't know. And even if today, let's assume that it was crystal clear the way they're applying their procedures now. The director comes and goes. The average tenure of a director is about 2 years, maybe 3. What's going to happen next? We don't know. It's very unhealthy. And it's caused, in my opinion, by the way the statute was written in the first place. There's a flaw in it that's allowing for all of this. And because IP is long-term, we need to finally find a solution here for this system so it just stops fluctuating. So just give us the rules of the road so we all know. We like them, we don't like them, we debate, but then come up with a set of rules, and then now we all know how to advise our clients on that on a long-term basis. So I think the statute has failed in this regard, and it's a major, major failure, in my opinion, as a result. So look, there is a proposed bill out there, the Prevail Act. I think it's a good bill. I think that would go a long way to fix this and make things clear, and we can talk about that. But that's just that's one possible solution. I'll say this about IPRs. I think, not to be provocative, but I'm not in office anymore, so who cares? I just think that there is a fundamental flaw with the concept of the statute. And the fundamental flaw is this. You're putting an adversarial procedure between two private parties over private property that's very meaningful and valuable in a political administrative agency. I don't think you can find other examples in government. Maybe Professor Lemley here will know. I don't think that you can find other examples in government where you have private disputes over private property resolved by political appointees. And there's a reason why the founders created an independent judiciary that is decidedly non-political, with lifetime appointments, so that these private disputes like this are resolved in a non-political, non-fluctuating way. And when you put it, when you have this dispute over such important issues between private parties in front of a political agency that changes policy every 4 years by definition, and probably more often than that, you have all the problems that you have right now. And one side or the other is not satisfied. And then you had to take it to the political extreme, where the Supreme Court says that you have to have, in the Arthrex case, you have to have ultimate responsibility lie with the political appointee, the director, because the director is accountable politically, and as if anybody votes for president based on what the PTO director does. But whatever, that's our system. So you have to have the political. So now the political appointee decides to make all the decisions himself in a black box system, and you don't even know if, in addition to policy issues, what other considerations might be in play. But that's just the result of a political system. That's why these issues have to be decided by the judiciary in general. But here we are, we have the statute, and the statute, since it's on the books, needs to be enforced. It should not be administratively killed, because that's improper. If you don't like the statute, go change it, have a debate in Congress, everybody come, have the debate with your members of Congress, have hearings, get rid of the statute or change the statute, or if you don't want it, fix it in other ways. But that, in my opinion, is where this needs to be fixed. It's a congressionally generated statute. Congress needs to fix it. That's why I think the bill is the right way to go. I also happen to think it's balanced and to achieve the original goals of the AIA. But either way, if you don't like it, then people should express their views, or if they like it, they should also express their views. But that's where, in my opinion, the debate should be.
So if the only solution that I guess stops this gyration is a congressional fix, what's your thought on kind of this loss of IP leadership at the congressional level? We've got Tillis retiring, lost Leahy. Anybody else care?
Well, we're also losing Durbin from Illinois, who's the #2 Democrat and cares a lot about IP. We're losing, I think, Marsha Blackburn from Tennessee, who I think wants to run for governor of Tennessee, and she also cares a lot about IP. And we begin with not very many people caring in the first place. But we still have folks. We definitely do. Senator Coons is a big champion, and he's still there, and will continue to champion IP, I'm sure. We have good members. Senator Hirono also very good on this. Senator Cotton on the Republican side. And then, in the House, we have a good number of leaders, Congresswoman Deborah Moran, Democrat from North Carolina, Deborah Ross from North Carolina, Nathan Moran from Texas, Republican, from the Eastern District, actually. They care a lot. Kevin Kiley from here, from California. So look, there are a few, but not all that many. But that's not new. It's always been the case, which is odd, because at least half of the U.S. economy is IP intensive, and according to the studies from the USPTO. And you would think that members would care at least about half of the economy, but it's not a sexy issue. It's really hard to discuss, Section 101 with them and PTAB, like what?
Well, looking at a few, well, actually, let's just go to the Prevail Act. Probably not going through this cycle, but it does get recycled from year to year, and we start seeing key concepts in it. Maybe it's fair to characterize it as big tech has got its problems with Prevail, and smaller, medium-sized enterprises seem to be more supportive.
Yeah, look, there's 3 bills, major bills, pending in Congress right now: Prevail, PARA, and Restore. PARA is Section 101. Restore is injunctions. You heard Ellison talk about that. And Prevail is on the PTAB. Of all 3, Prevail on the PTAB is the farthest along. In fact, there was a hearing in the subcommittee a year ago in the last Congress, and the bill passed the subcommittee. So that was a big step. It needs to be brought to the full Senate for vote. Do I think it's going to pass? I don't think they can pass, naming a new post office nowadays. But yes, I think all these bills actually could pass. Here's the sure way it's going to pass, all these bills, okay? You get President Trump to put out a tweet, or whatever channel he uses nowadays, Truth Social, I guess, that says something like, "Stop China's theft of American innovation, vote yes on Prevail," or Restore, something like that. I'm kidding a little bit, but the reality is, if the administration gets behind one or more of these bills, then the Republicans will almost for sure get behind them. And there are enough Democrats who support this, like Senator Coons, Hirono, etc., Durbin, and I think it can pass. So it really is up to the administration, in my opinion. And it's really interesting to review the comments on the NPRM. The deadline was yesterday. As I said, thousands of comments. But look at the ones from the major organizations. Okay, IPO is an example. AIPLA. Okay, they don't really support it per se. They say they support the general concept that you should have only one bite at the apple and the like, and they support the directors' drive to strengthen the IP system. But there should be many changes. But then the key is that they say that the better course of action is to go with Prevail, and encourages the administration to get behind Prevail. The senators that I've mentioned and the House members also put in a comment along the same lines. We generally support your efforts, but you should just get behind Prevail. So if the administration does that, it can definitely pass. And by the way, you don't even need a full Senate vote. It can be attached to a must-pass piece of legislation, such as the annual National Defense Act. It's not unheard of. The Trademark Modernization Act in December of 2020, which is the biggest piece of trademark legislation in 50 years, was just tacked on to the defense bill, and it passed with a bill. Obviously, you have to pass the defense bill. Unclear what trademarks had to do with that defense bill, but that's the way bills work in Congress. So it is possible that that happens, but it will not happen without the administration getting behind it.
So to push back on that a little bit, when you look at what's happening with the PTO now, it doesn't look to be anything close to the Prevail Act and what's being pushed on that side. And is there any way that the director is acting without knowledge that there are already several senators backing the Prevail Act? And is this already kind of a thumb at the Senate saying, no, this is not the way I'm going?
Well, I don't know. I can't really speak for them. I don't really know what they're thinking, but I'm sure that they know about the Prevail Act. I'm sure the director knows. There's no question. The NPRM definitely goes beyond Prevail. So I don't know if they have, maybe they're positioning to actually pass Prevail, so as a compromise bill. Hard to speculate.
So the other one you mentioned doesn't get a lot of press in the last several months, and that's PARA. And how does PARA relate to what you see the administration talking about on AI?
Yeah, so PARA is on Section 101. There have been hearings on PARA. There have been at least 2 hearings already in the last couple of years. I've testified at them. It's more controversial. It's more difficult to explain, and it's a fundamental shift in policy, and there's a lot of political pressure on PARA from patient advocacy groups and obviously from big technology companies, et cetera. So I don't know. We'll see. At the last hearing, which was just a month ago, Senator Tillis, who's retiring at the end of next year, and this is one of his signature bills, he said that one of his main goals is to get PARA to a vote before this congressional session ends. So we'll see if he manages to do that. I do think the administration could get behind it. For sure, it is in line with the directors. The director just today put out the Section 101 piece of guidance. I don't know if you've seen it. It was this afternoon. So he's very interested in Section 101. He's already given at least a speech on Section 101. He wants, especially from business method perspective, fintech. He wants patents on that stuff. So he's definitely interested. So I think theoretically they could get behind it.
And so the last piece, you notice how these start lining up with what we talked about today is the Restore Act, which is dealing with this issue of injunctions and how injunctions are fairly difficult here in the United States now.
Right. So Restore basically would go to status quo anti-eBay, effectively. It would create a rebuttable presumption that a patent that's been found valid and infringed should be entitled to an injunction. But again, it's an equitable remedy, so it's rebuttable and so on. It's, believe it or not, first of all, it's third in line behind these first 2 that I've mentioned. Just chronologically, it hasn't had as much airtime in Congress yet. But believe it or not, I think it's simpler. It's a 1-sentence bill. It's really easy to understand. And of all 3, a member of Congress can really easily understand this. If you just walk down the halls of Congress and you mention Section 101 or PTAB, their heads will explode. They won't even stop on their way to the bathroom. But if you mention injunctions and you say to a member just walking by, hey, Senator, do you know that you cannot get an injunction on a patent? You cannot stop an infringement of a patent. Now, of course, that's an over-exaggeration, but let's just assume you say that. They will say, what? Patents, of course, are about stopping other people. What do you mean we cannot do that anymore? So they get it. So that's an easier lift. I also think it's an easier lift in the administration, believe it or not. I think it's a really easy lift in the administration. And here's proof positive. Unprompted by anyone, the Department of Justice, okay, the whole department, which means, it's the antitrust division, but they don't do it if the Attorney General would say no. So you have the Department of Justice and the Department of Commerce voluntarily drop into this case and put in a statement of interest, as I mentioned in the Radian case, that injunctions are important. So their head is already there. And so I think theoretically it's doable. And I'm telling you, if the administration affirmatively says that they're supporting the Restore Act, that can happen in a blink. Now, of all three, it would have the most meaningful impact. It would be a dramatic impact immediately. And that's also why, if it were to happen, you would have huge, voices speaking for and against. People would start making a huge deal out of this because, obviously it's very consequential. Now, I'll say this about injunctions. I heard on the previous panel about, NPEs and, and maybe they should get different treatment and all of that. It really is weird to have an intellectual property system without a robust system for injunctive relief. Obviously, it has to be equitable, and there have to be a balance of factors and whatnot. But it's odd to have that and to say that if you're a non-practicing entity, you presumptively shouldn't have an injunction. And that's basically the situation we have here in the United States. It's not on a competitor-to-competitor issue, but if you're not practicing, it's really almost impossible to get an injunction. That's odd in my view. If you think about it just logically, assuming that patents are property. What other property comes along with this system? So, first of all, let's assume I like your watch, which I don't actually like it very much, but let's assume you wore actually a nice designer watch, and I like it. I come and take it off your arm, off your wrist, and I just take it. And you sue me, and you say, I want my watch back. And I say, well, just sue me, and we'll litigate. And at the end of it, I'll just give you some money for it. If you win, if you prove everything, I'll just give you some money for it. But you can't have your watch, because it's not. You can't enjoin me from keeping your watch. That's odd. Now you're wearing that watch, so you're a practicing entity in that example. But assume that you're a collector and you have your watch at home and you have 5 watches at home and you just never wear them. And I know some people like that. And you don't wear your watch. I can give a better example. An automobile. You have a collector of automobiles and they just don't drive this particular car. And somebody comes and takes it and says, okay, I'm going to use it. I'm going to be an Uber driver and use that car. And I'm going to really put it to good use for society, not like you who's hoarding all this stuff and you're never driving your vehicle or wearing your watch. I'm just going to take it. And you know what? At the end of a 5-year litigation, if you succeed and spend $10 to $20 million, I'll just pay you some money for that. What other, it's inconceivable. No, nobody, it's laughable. Nobody even thinks about having these discussions about private property. Same thing with real estate. Just because you don't live in a building and you're renting it out, nobody says you can't, you don't have the right to evict a trespasser just because you personally don't live there. This concept seems to be applicable only to intellectual property. And I think that's a newish thing in the West, especially in the United States. It's newish, past couple decades or so. And it goes back to that tension that people have about IP. That it's, on the one hand, people do systems want to protect the innovator and the creator. On the other hand, there's this whole concept of access that people struggle with. And because it's an intangible property, And it's a non-exhaustive property, right? Because these are concepts; they're not exhaustive, like personal, real property, tangible property, that is. People can resolve these things, and it all comes down to this breakdown in how you think about IP as property, and it's manifesting in these issues. And we go to these extremes. A much better system is to be a balanced system, to obviously allow for injunctions, but obviously have, go through the various analyses and see if it's applicable. But you can't just say in a de facto way that, a non-practicing small inventor cannot exclude. And it's having perverse results. It lengthens litigation. It makes it more expensive to get to the end of the day. So I think, folks are, that's one of the reasons folks are pushing the Restore Act. We'll see where that goes.
So last question. I'm going to give you the president's phone. You get to send one tweet or Truth Social out on patents. We're going to stay away from everything else. What's the one thing you would want to have changed kind of for long-term stability? You just get 142 characters.
Oh my God, there's so many things. Look, the ultimate goal is to make patents and IP steadier. We need to steady the ship, and one way or another, and there's many levers that go into that. I don't know if I can just do one thing. Everything we discussed about goes into it. I'll throw in one more thing. The PTO director changing every 2 or 3 years is insane. This fluctuation in direction in policy is very damaging in a effectively non-political entity. Look, ultimately, if there is one major top-level thing that I would hope legislators and the public understands, goes back and harkens to the Constitution. And I would, if I'm the president, I would really tweet out one thing, respect IP, protect IP, make it meaningfully enforceable. But at the same time, keep a balanced system. Don't have these wild swings from one side to the other. So I think I can get that in 140 characters, but I have to work on it.
Later on, people can ask you which ones you'll bold and put in caps. So with all that, we're out of time. Andrei, thank you so much for joining us again.
Pleasure.